Thank you, and let me join Dean Reuter in welcoming you to this second panel, which is on the subject of racial preferences and promoting diversity. Are these policies taking us in the right direction? I'm Roger Pilon. I'm the director of the Cato Institute's Center for Constitutional Studies and vice president for legal affairs at Cato. From our outset as a nation, we've had difficulty fully respecting our founding principles, none more so than our belief that all men are created equal and entitled to equal treatment under law. From our constitutional compromise over slavery to our acceptance of Jim Crow after the Civil War, we've struggled until finally, in the middle of the last century, we resolved to deal with the issue head on. But so embedded in the South was discrimination as a social institution that we decided, correctly I believe, to root it out nationwide, not simply in the public, but in most private institutions as well, hoping perhaps that the attitudes that required so wrenching a remedy would abate sufficiently over time to enable us eventually to restore a greater measure of private associational freedom. Thus, to ferret out those often disguised attitudes, we invented a disparate impact theory of discrimination, the subject of the last panel. And we required institutions to get their numbers right through affirmative action, even though such action itself entailed the very discrimination we sought to eliminate. We rationalized that by thinking we were rectifying past wrongs, even though those now discriminated against had most often done no wrong, and those benefited by the practice had suffered no wrong, a point that became only more clear as time went on. And so, as the rectification rationale grew less credible, a new rationale for affirmative action's discrimination had to be crafted, and it took the name diversity, the subject of this panel. No longer imagining that we were not discriminating, we wanted institutions, public and private alike, to, quote, look like America, even when they failed to do so simply because they reflected the choices of individuals freely making for reasons they thought best served their individual interests. But if, as has been famously said, the way to stop discrimination on the basis of race or any other forbidden ground is to stop discriminating on the basis of race, then should we enforce that non-discrimination principle across the board, not only against public institutions where it's rightly enforced, but against private institutions as well, institutions that may have their own reasons for wanting to discriminate, including reasons rooted in the perceived virtues of diversity. And equal treatment aside, what are the practical consequences of either requiring or prohibiting diversity practices? We're fortunate today to have a distinguished panel to discuss these questions. In your folders, you have their bios, so I'll give them just a brief introduction now, after which we'll address these diversity issues. Each will do so for about 10 to 12 minutes, followed by a brief exchange among our panelists, and then I'm going to open up to questions from the floor. We'll begin with Stuart Taylor, who is an author and freelance writer focusing on legal and policy issues, and a Brookings Institution non-resident senior fellow. He has co-authored 2 critically acclaimed books, including Mismatch: How Affirmative Action Hurts Students, It's Intended to Help, and Why Universities Won't Admit It. That was a book that was available earlier outside, and Stuart will be happy right after this program to sign those of you who picked up copies of the book. Stuart is a graduate of Harvard Law, former associate at Wilmer, Cutler & Pickering. He's been a reporter for the New York Times and the commentator and feature writer for the American Lawyer, Legal Times, National Journal, and Newsweek. We'll then hear from Hans Bader, who is a senior attorney at the Competitive Enterprise Institute. He's also a graduate of Harvard Law. He's practiced education law, including a stint at the Education Department's Office of Civil Rights. His prior casework has included suits involving the First Amendment, federalism, and civil rights issues. Before joining CEI, he was a senior counsel at the Center for Individual Rights. Finally, Michael Seidman is the Carmack Waterhouse Professor of Constitutional Law at the Georgetown Law Center, where he has taught since 1976. He too is a graduate of Harvard Law. We have a whole Harvard panel up here. He clerked for J. Skelly Wright of the DC Circuit and also for Supreme Court Justice Thurgood Marshall. Among his several books are On Constitutional Disobedience from Oxford and Equal Protection of the Laws from the Foundation Press. So please welcome our panel, beginning with Stuart Taylor.
Hello, and thanks very much to the Federalist Society and Cato and Heritage, what a team, for including me in this important discussion. I'll start with a very quick recent historical note and then move on to my main subject. The recent historical note is, and I'm reminded of this by the program, during the campaign in 2007, actually, President Obama spoke briefly about affirmative action. He was asked by George Stephanopoulos. And without quoting the whole exchange, I'd say, President Obama said, well, his daughters should be considered pretty privileged, and maybe there should be preferences for lower-class whites. And he seemed to be moving toward something different than the traditional race-based affirmative action, something more like perhaps class-based affirmative action. And now, flash forward, Attorney General Holder was most recently heard saying, quote, I can't actually imagine a time in which the need for diversity will ever cease. And in context, it's quite clear he was talking about raw racial preferences when he said diversity. So there's been something of a bait and switch there, a rather unremarked bait and switch. But I'm going to focus on just one of the many problems with racial preferences, and I think Hans may speak a little bit more broadly. The problem, which in my opinion is the cruelest consequence of racial preferences in university admissions, is that the most grievously damaged victims of these racial preferences are the supposed beneficiaries, especially the supposed African American beneficiaries. And in an ugly irony, the most seriously harmed victims of all, on average, are the descendants of black slaves, because they are the least prepared for academic, on average, of course, the least prepared for academic competition, and thus the most academically mismatched with their classmates and academic competitors. I'll briefly summarize the conclusions of the 2012 book that Roger mentioned with my co-author, Rick Sander of UCLA Law School, who's perhaps the leading empirical researcher in this area. And if anyone has a really deep empirical question for me, I may have to get Rick on the phone. Now, the arguments why racial preferences are unfair to many whites, which have been summarized by Roger Clegg, recently departed, as well as anyone, and especially Asians, have been well made for more than 40 years. But the use of racial preferences and their political entrenchment in elite circles has increased all the while. In the words of the estimable Heather McDonald, quote, mismatch theory is the most powerful critique of affirmative action yet developed, end quote. And I dare hope it may have more of an impact on what's actually happening out there, the mismatch argument, than some other arguments have had. And of course, affirmative action, goes without saying, has become a misleading euphemism for racial preferences. The major engine of mismatch is not the simple fact that racial preferences are used pervasively by almost every selective university in the United States, college and university. That's clear enough. But that alone doesn't produce mismatch. If it was a little finger on the scales every time a racially preferred group comes up against somebody else, if it was, well, we'll give this one a 50-point bump on the SAT or a 1/3 of a grade point average bump on grades, it might produce all kinds of problems, unfairness, but it wouldn't be a big mismatch issue. Mismatch is not about the fact of racial preferences. It's about the size of racial preferences. And the fact is that the racial preferences and the gaps in academic preparation between most entering students in the racially preferred groups and most of their classmates are enormous. According to a leading study of mean SAT scores, study done by two advocates of racial preferences, I should stress, Thomas Espenshot and Alexandra Radford, the gap between the mean SAT scores of blacks average 450 points out of a 1600 scale, below the Asian American mean on a 1600 point scale, 310 points below the white mean, and 180 points below the Hispanic mean. High school grades, adjusted by the quality of the high school, tell a similar story. These are enormous gaps. And a foreseeable but widely suppressed result is that these students tend to be unprepared for and shocked by the academic challenges they encounter once arrived at colleges. They're set up to fail by being brought without warning into a highly competitive situation with students who are much better prepared than they are. They're likely to struggle academically, become demoralized, and bomb out of the academically challenging courses that are gateways to some of the most desirable professions. This isn't a critique of these students. This is a description of the dilemma they're put in. It's a terrible position to put people in, especially when you're deceiving them to get them there, which is what the universities are doing. Oh, you're going to do fine. You're very well qualified. That's what the university's message to these students is. And so they're victims of academic mismatch. And the thrust of our book is using a lot of empirical data and some anecdotalage that do much better academically, perhaps better in their careers, perhaps have happier lives, if they attended less selective but still competitive schools for which they're well prepared. A student who goes to, let's say, Brown or Harvard or Georgetown, who might be very well qualified for, let's say, Catholic University or American University, tends to do very badly at the fancy schools that he got into when he might have done very well at the less fancy school that his peers got into with similar qualifications. An outpouring of, well, mismatch theory rests on a foundation of facts that are undisputed among experts, although hidden from view by academia, the news media, and the government. These include the SAT gaps I mentioned, for example. I don't think you'll ever find them in the New York Times, or if you do, it'll be very, very deep. Mismatch theory is also winning more acceptance in scholarly and other legal circles, although you won't find much about that in the major newspapers. An outpouring of empirical evidence by my co-author Rick Sander and many others, Peter Arcidiacono of Duke University, Doug Williams of Sewanee, and many others, shows that the consequences of huge racial gaps in academic preparation are what common sense would lead us to suspect. Black students, and to a lesser extent Hispanics, clustered toward the bottom of their classes. About more than half of black students in the bottom 20% of their classes, I believe the numbers are. Most who aspire to major in science, pre-med, or engineering flee to soft courses. And they're not going to be doctors, scientists, or engineers, even though they might have been had they gone to a college for which they were well qualified. Most black students, according to surveys, conspicuously lack academic self-confidence relative to others. Black law graduates flunk the bar exam at 4 times the white rate. More tellingly, even when compared with whites who have very similar undergraduate academic records and LSAT scores, i.e. with whites who enter law school as more or less their academic clones, blacks flunk the bar exam at about twice the white rate. This is happening in law school, not before law school, and we submit it's happening because they're in the wrong law schools to maximize their gifts. This fact alone suggests that the reason so many blacks flunk the bar is the racial preference regime that funnels them to law schools for which they're not well qualified. As a result, we may have fewer black and Hispanic lawyers, and also doctors, scientists, engineers, and professors than we would if admissions were race neutral. More generally, large racial preferences place the best minority science students in the schools where they're least likely to achieve their goals. This has been copiously documented in the context of the sciences by Rogers Elliott's pioneering 1996 study at Dartmouth of Ivy League students and 3 more recent studies. It's been rebutted, as far as I can tell, by nobody. Many people have purported to rebut, and I think unpersuasively, Rick Sanders' law school mismatch thesis. I'm not aware of anybody who's tried to rebut the thesis of science mismatch, and Gail Harriott and others at the Civil Rights Commission have done great work on that too. Indeed, because so many black students who aspire to be scientists wash out of the sciences at schools where they are mismatched, historically black colleges and universities produce 40% of the blacks with bachelor's degrees in science and engineering, even though they account for only 20% of black college enrollment. As one professor at an HBCU observed ruefully, quote, "The way we see it, the majority schools are wasting large numbers of good students. They have black students with admission statistics that at the HBO would be very high, tops, but these students wind up majoring in sociology or recreation and get wiped out altogether," end quote. Then there's the pervasive dishonesty at the heart of the racial preference regime. Highly selective schools, as I indicated earlier, systematically deceive, not to say defraud, their affirmative action recruits by telling them that they are well qualified, while failing to disclose that, quote, point, most will rank near the bottom of the class, be unable to pursue aspirations for careers in professions requiring exceptional academic performance. These universities also conceal from racial preference recruits that their chances of success in such professional fields would be greater if they attended somewhat less selective schools where they would be more competitive with their classmates. Another key point, and I'll move to a close, is that the current racial preference regime makes economic inequality worse, not better. Working class and poor Asian kids are systematically passed over to admit more affluent, less well-qualified black and Hispanic students, many of whom are children of well-off parents, often immigrants. Our book and our related amicus brief propose 2 principal, relatively modest reforms for adoption by the Supreme Court in an appropriate case. The first is to require that the operation and effects of universities' race-conscious admissions and other preference programs be totally transparent and fully disclosed. Second, the court should require universities to stop giving race-based preferences to affluent black and Hispanic applicants over better qualified working class and poor Asians and whites who are also less well off. The first reform would equip minority applicants, their parents, and policymakers alike to make better informed decisions. The second reform would provide a healthy incentive for selective schools both to enroll more outstanding working class and poor students, which provide more intellectual diversity than the current regime, and to reduce the mismatch problem. I've never heard a coherent objection to either proposed reform, except that many critics of racial preferences fault Rick Sander and me for stopping short of urging the justices to outlaw racial preferences in state programs entirely. And I'm sure if Roger Clegg didn't have to leave, he would be doing that in a minute. So I'll stop. Thank you very much.
In its college admission decisions, like Fisher and Bakke, the Supreme Court has said race can be used to pursue the educational benefits that flow from student body diversity. Such racial preferences, it has said, are allowed because of college's academic freedom. Logically, then, you could argue that diversity is limited to higher education as a rationale for using race. Indeed, appeals courts have rejected or questioned diversity as a reason for using race outside the educational setting in court rulings like Lutheran Church Missouri Synod versus FCC and Police Association versus New Orleans. Even the use of gender to promote diversity was struck down in Lamprecht versus FCC. But liberal lawmakers and the Obama administration have a different viewpoint. They have expanded the use of race and gender. For example, the 2010 healthcare law contains workforce diversity grants. Obamacare also creates a new medical academy, the United States Public Health Sciences track, that will give priority to underrepresented minorities in admissions. Ironically, this section does not invoke diversity, but seemingly rests on an underrepresentation rationale rejected by the Supreme Court's 1978 Bakke decision. The Dodd-Frank financial reform law also contains racial preferences. It seeks to increase diversity among suppliers and workforces of agencies. Its Section 342 creates new diversity directors at each federal financial regulator. It prods agencies to give more jobs and contracts to minorities, saying that each agency shall take affirmative steps to seek diversity in the workforce and develop standards for increased participation of minority-owned and women-owned businesses. This section also provides that each director shall develop standards for assessing the diversity practices and policies of entities regulated by the agency. In 2013, federal regulators proposed diversity guidelines for all banks and financial firms they oversee, including metrics and percentages as tools for promoting diversity. Critics objected that regulators had gone beyond assessing banks' diversity policies to dictating them and ignored constitutional limits on the use of race and gender. As the administration pushes for diversity even beyond its traditional setting, it's worth revisiting whether diversity even works. In fact, diversity appears to be ineffective at increasing overall student achievement and success. To many in academia, nothing seems to matter more than racial diversity. For example, racial preferences at the Naval Academy were defended by saying that, quote, diversity is the #1 priority. Many black students are admitted there after remedial classes at a special preparatory school. But if diversity is necessary for learning to occur, why are educational outcomes so much poorer in diverse jurisdictions than non-diverse ones? Hawaii is the nation's most diverse state. No single racial group is a majority, and it has no Jim Crow legacy. Moreover, it's diverse not just on a statewide level, but on a school-by-school basis, meaning that diversity goes all the way down to its capillaries. It's one of only 2 states where the average white student doesn't attend a school that's majority white. And what's the result? In 2013, out of 50 states and DC, Hawaii ranked only 39th in its high school graduation rate, 44th on its SAT scores, and 41st on the ACT. By contrast, Vermont, which is America's whitest state, 95.4% white, has the nation's highest graduation rate and ranks better than average on standardized tests. The nation's 3 whitest states all have much higher than average high school graduation rates. By contrast, the nation's 3 most racially diverse jurisdictions, such as DC and Hawaii, all have lower than average graduation rates and lower than average test scores. That's so even though the DC schools have more money than God, according to Education Secretary Arne Duncan, and even though Hawaii's population is composed mostly of ethnic groups that perform fairly well in other states. The 3 states with the highest test scores, when you average together the SAT and ACT, are all whiter than average and not diverse on a school-by-school basis. Those states are Minnesota, Iowa, and Wisconsin. Minnesota is 88% white and boasts the nation's highest overall scores, ranking 4th on the SAT and 6th on the ACT. It also has the 4th highest graduation rate. Most racial minorities in Minnesota are concentrated in a few urban school districts, leaving the vast majority of the state's school systems overwhelmingly white. Similarly, Iowa is the 7th whitest state, with the 5th highest graduation rate. The bottom 3 states in terms of test scores are all much more diverse. North Carolina, Florida, and South Carolina have the nation's lowest test scores if you average the SAT and ACT. The top 3 states in high school graduation rates, Vermont, North Dakota, and Wisconsin, are all overwhelmingly white, while the bottom 3 states, Nevada, D.C., and Mississippi are much more racially diverse. For example, Nevada, the state with the worst high school graduation rate, is more racially diverse than the U.S. as a whole, owing to its above-average percentage of Hispanics and Asians. Yet, in Supreme Court cases like Parents versus Seattle School District, defenders of racial preferences claim that racially balancing school populations, such as race-based busing of students across a city, somehow improves educational outcomes. In the real world, there is no obvious benefit. Black students don't seem to benefit much from racial diversity either. Student achievement in overwhelmingly black Caribbean countries like Barbados is often better than among blacks in the US. That's true even though there are few whites in the Caribbean and racial diversity is often absent. Yet the people of the Caribbean, with few white people around, have proven to be very creative. The impoverished little island nation of St. Lucia, saddled with an illiteracy rate of 45% at the end of the Second World War, went on to produce the first black Nobel Prize winner for economics and the second black person to win the prize for literature. This is true even though the Caribbean has historically been poorer and suffered much worse under slavery than the southern US, with many more blacks dying from slavery in the Caribbean than in the United States. With few white people around, Caribbean islanders do not view studying as acting white the way black students in the US sometimes do, according to my relatives there. Many high-ranking black professionals like Attorney General Holder are descended from Caribbean immigrants. In cases like Fisher, the Supreme Court has upheld the use of race to promote diversity, as long as colleges claim to be seeking diversity in general, not just racial diversity. But in fact, colleges dislike non-racial diversity, and their fetish for racial diversity ends up excluding poor whites in favor of more affluent applicants who know how to exploit diversity jargon. Princeton sociologist Thomas Espenshade found that poor white applicants were 3 times less likely to be admitted than wealthy white applicants with the same grades and scores. I can tell you from experience one reason why this is so. Poor white applicants, unlike wealthy ones, don't know how to use diversity jargon or speak diversity speak. The wealthy white student who spends a couple months in Zimbabwe working for Oxfam then boasts about his diverse experiences on his college application, thus minimizing the negatives associated with being white. The poor white applicant doesn't, even if she does speak about her hardships, like being the child of working-class immigrants who spent long hours working in an ice cream parlor, or attending an inner-city school where she and her sister were 2 very passive, very frightened little white girls. That merely gets her rejected, even when she had good grades. These are actual applications I read in the course of suing a college many years ago over its admissions policy. For wealthy white people, diversity promotion activities, such as traveling to foreign countries, are the modern equivalent of the 18th century grand tour, when wealthy Englishmen, upon completing college, would tour France and Italy in search of art and culture. Poor white people can't afford foreign travels. They need to work to put themselves through college, and they don't usually know how to engage in politically correct signaling of the sort engaged in by wealthy, politically connected college applicants. Colleges discriminate against Asians in admissions, even though Asians often have very diverse life experiences, whether it's growing up the child of survivors of Cambodia's Khmer Rouge Holocaust, or being the child of Vietnamese boat people. Diversity is often used to promote racism and racial stereotypes. For example, Glenn Singleton, a wealthy diversity trainer hired by many colleges and school systems, such as Arlington and Montgomery County, has claimed that white talk is impersonal, intellectual, verbal, and task-oriented, while color commentary is emotional. If a white person said this, it would rightly be regarded as a racist stereotype that relegates black people to intellectually inferior status. But Singleton can get away with it. He's also claimed that individualism is a form of racism. Diversity training doesn't work, according to a 2012 article in Psychology Today, which noted, diversity training doesn't extinguish prejudice, it promotes it. When we discuss using race to promote diversity, the assumption seems to be that it's a voluntary exercise of academic freedom. But the pursuit of diversity is often not really voluntary. It occurs against a backdrop of bureaucratic pressure to use race from civil rights agencies and government-backed accreditors like the American Bar Association. Even when such pressure is illegal, it can be quite effective. State regulations and financial aid regulations often require that a school be accredited. Accreditors like the ABA use that condition as leverage to force some schools to use racial preferences in admissions. Back in 2008, a member of the U.S. Civil Rights Commission noted that ABA accreditors had been threatening to pull the accreditation of George Mason University Law School, a well-rated law school, for its failure to adopt illegal racial quotas in admissions. The ABA first forced GMU, one of the few law schools without a marked liberal bias, to use what the ABA itself referred to as a preferential affirmative action admissions program to radically increase its minority percentage from 6.5% to 19%. But the ABA still wasn't happy with the results, which were insufficiently extreme for the ABA's quota mongers. GMU and its president and law dean were then personally summoned to appear before the ABA. Never mind that the qualified applicant pool for a law school of GMU's caliber is way lower than 19% minority, as was the percentage of non-white lawyers. So it's not as if having 19% was a sign of discrimination against minorities. Indeed, the ABA conceded GMU has long had a very active effort to recruit minorities, even before adopting racial preferences. Technically, the ABA's actions violated 42 U.S.C. 1981 and the Supreme Court's Gratz ruling, which held in footnote 23 that racial quotas violate not just the 14th Amendment, but also Section 1981, which bans discrimination even by private entities. But predictably, no challenge was ever brought, given the risk of ABA retaliation. George Mason's situation is far from unique. Other law deans have also reported pressure from accreditors like the ABA to use race in ways seemingly forbidden by the Supreme Court's decisions. For example, Dean Huffman of Lewis and Clark testified in Smith versus University of Washington Law School that accreditors pressured his law school to expand its racial preferences. Bureaucratic pressure can also create an incentive for some large employers to support racial preferences in college admissions, even when the employer deep down doesn't like racial preferences and understands how they undermine merit-based hiring in its own workforce. Under the 1991 Civil Rights Act, an employer can be liable for disparate impact, such as for job applicants passing a test, for where job applicants, more blacks than whites, fail a test. The higher minority failure rate makes the test illegal unless the employer can show it's justified by a business necessity. Almost all hiring criteria that weed out less qualified applicants have a racially disparate impact. In theory, the solution to such disparate impact is either to prove the test is justified or get rid of it. In real life, the employer would rather keep the test to weed out unqualified employees, even if it's imperfect, as most cheap selection criteria are. Moreover, no matter how justified the test may be, a civil rights agency can still sue it over the test and force it to spend millions of dollars validating the test, only to run the risk that a judge will disagree and declare the test illegal. So what does the employer do? It uses race in hiring to mask the inevitable disparate impact of its hiring criteria. It also uses seemingly race-neutral hiring criteria that generate more minority hires, like hiring graduates of an otherwise selective college that has a significant black student population due to the fact that blacks were admitted with lower grades and SAT scores than their white peers. A large corporation that is desperate to raise its percentage of black employees without using overt racial preferences that might attract a reverse discrimination lawsuit may thus find it convenient that selective colleges have racial preferences. Small wonder then that some large corporations filed amicus briefs with the Supreme Court urging it to uphold the use of race in admissions in 2003 and the University of Michigan cases. By contrast, businesses oppose racial preferences imposed on them, such as diversity rules for regulated industries and government contracts. In theory, an employer doesn't escape liability for disparate impact by using racial preferences to offset it, and instead has to get rid of the test that has the disparate impact. That's what the Supreme Court ruled in Connecticut versus Teal. But in the real world, what matters isn't what the Supreme Court said long ago, but what civil rights agencies that can sue the employer say today. And those bureaucrats say you can use racial preferences to offset disparate impact, as the EEOC made clear in its 1978 Uniform Guidelines. As a result, some large businesses use racial preferences in favor of minority applicants to offset the disparate impact of selection criteria designed to maximize the qualifications of their employees. And the 1978 guidelines have been essentially served as bureaucratic encouragement to use racial preferences. Thank you.
Okay. Oh, yours, okay. Thank you so much for coming. I want to thank the Federalist Society for inviting me. Whenever I appear at Federalist Society events, I always congratulate the Federalist Society for their effort to provide a fair and diverse group of people talking about an issue. In this case, though, I do think perhaps through no fault of their own, they've fallen down a little on the job. So not only is everybody here from Harvard Law School, I guess under the circumstances, I ought to point out everybody on this panel is white and everybody's male. But more to the point, there is not on this panel a kind of full-fledged, unambiguous defender of affirmative action. My own views about this are somewhat wishy-washy. On balance, I support at least some forms of affirmative action, but I think the question about whether they do more good than harm is close. And unlike many people on both sides of this issue, I think reasonable people can be on both sides of the issue. I don't think everybody who's on one side or the other is necessarily a racist or an ideologue or anything like that. So, for the sake of diversity, let me start by talking about what seem to me to be some bad arguments against affirmative action, and then say a word about what might be some good arguments. So, the first really bad argument, affirmative action is unconstitutional. I suppose if I were a better person, I'd resist the urge to point out the monumental hypocrisy of the conservative justices on this subject, but I'm not a better person, and so I can't resist. I'm prepared to stand corrected, but I believe that there is not a single opinion ever written by a single conservative justice on affirmative action that examines the original public meaning of the 14th Amendment, the original expected application, the intent of the framers, or anything like that. Instead of lovingly massaging the constitutional text that we get with, say, the Second Amendment, what we have instead is a steady stream of moral bromides and pop sociology of the sort that the conservatives deride when they appear in cases about things like gay marriage and abortion. So, for example, we have the spectacle of Chief Justice Roberts claiming that affirmative action is unconstitutional because, in his considered opinion, it's a dirty business. Or Justice Thomas opining that it's unconstitutional because he thinks African Americans can succeed without it. Similarly, somehow all of the sermons about democracy and deference to the political branches and the evils of judicial activism suddenly go out the window when we're talking about affirmative action. That kind of hypocrisy reached a kind of climax last term in the Stuart case. That's a case where the court upheld a Michigan referendum that banned affirmative action. To give you a flavor of Justice Kennedy's opinion, and by the way, Chief Justice Roberts is largely along the same lines, let me just read a little of it to you. Here's what he says. Were the court to rule that the question addressed by the Michigan voters is too sensitive or complex to be within the grasp of the electorate, or that the policies at issue remain too delicate, or that these matters are so arcane that the electorate's power must be limited because the people cannot prudently exercise that power even after a full debate, that holding would be an unprecedented restriction on the exercise of a fundamental right to speak and debate and learn, and then it's a matter of political will to act through the lawful electoral process. Well, from that language, you might think that Justice Kennedy favors resolving the debate over affirmative action by democratic processes. But of course, nothing could be further from the truth. When the government enacts affirmative action measures, after, I should say, full debate and lawful elective processes, he's virtually always, indeed I think always, on the side of those who say that the matter is too arcane and too sensitive to be resolved politically. It's only when people vote against affirmative action that he favors democracy. So this is democratic government so long as people vote the right way, and of course that's not democratic government at all. A second bad reason for opposing affirmative action. People who get into colleges and graduate schools on other criteria deserve their seats, and it is therefore unjust to take them away from them. One hardly knows where to begin to attack this silly and pernicious idea. We might start with the fact that a large number of seats are awarded on other grounds that obviously have nothing to do with academic merit, based on things like athletic ability, or the family's contributions to the institution, or legacy preferences, or geographic distribution, or I might add, and this goes on all the time at my law school, the kid's father happens to have a faculty member as a friend. There's no one talking about mismatch theory with regard to any of those people. Putting all that aside, the dessert point rests on the obviously false premise that people start from the same position. Now, I was lucky enough to be born into a family that had a house full of books, that was upper middle class, where my parents made clear that they would pay for all the education I wanted, and where from the youngest age, every meal consisted of a Socratic dialogue conducted by my father about philosophy, literature, and current events. If you wonder why I'm such a strange person, there you have it. I'd like to have credit for choosing my family, that I just really made a good choice in who my parents were. But of course, the truth is I didn't really have much to do with it. African Americans, on average, they earn about $1 for every $2 earned by white people. Much more dramatic if you look at family wealth. The family wealth of white people is 6 times that of African Americans, and that gap is widening, and it's larger than existed in apartheid South Africa, okay? Many more black children than whites grow up in poverty. A huge percentage of them have their fathers locked up in prison. They attend inadequate and violence-ridden schools. It's an obscene joke to say that those kids have an equal chance to get into universities as non-African American kids. And then we have the criteria for admission. Let's talk about law schools for a moment, which is the subject I know the most about. At Georgetown Law School and virtually all other law schools, admission is determined largely by an LSAT score. Most of the LSAT measures one's ability to perform high-speed abstract logic games, which as far as I can tell have absolutely nothing to do with any attribute that we ought to care about in lawyers. Now, it is possible to develop a skill in those games, but it's close to essential to take some course that explains to you how to play them, courses that are out of the reach of many minority applicants. Does anyone for a minute think that if a test like that produced an entering class that was overwhelmingly African American, that we'd continue to use it? I don't believe that. The final bad argument against affirmative action is that admission decisions are non-discriminatory in the absence of affirmative action. And so it is said affirmative action is a racial preference. That's another sad joke. Study after study demonstrates that evaluations of African Americans are pervasively influenced by unconscious bias. The most famous of these, now done on hundreds of thousands of people, is the Harvard Implicit Bias Test. If you haven't done so already, you can take the test, go online, Google Harvard Implicit Bias Test, and try taking it. I think you'll be surprised by the results. It's really eye-opening. There are libraries full of studies demonstrating that, for example, college professors, including liberal college professors, including black college professors, are less willing to make an appointment to see students with identifiably African American names, or that people making job decisions react to identical resumes differently based on whether the person submitting the resume is identifiably African American. Given all that, I think it's probable that affirmative action is not really a special preference at all. It does no more than partially compensate for the pre-existing, pervasive, mostly unconscious racial bias that runs throughout the evaluation process. So those are bad arguments against affirmative action. What are reasons for being skeptical of affirmative action. I myself think that the issue turns not on deep issues about theories of justice, but instead on thoroughly practical concerns. That is, does it work? Does it do more harm than good or more good than harm? And for that reason, I think at least Stuart's approach is the right way to think about it. He's asking the right sort of questions. So how might it do harm? Here are some ways. First, I worry that it stigmatizes African Americans. So when African Americans do well, the supposedly special treatment that they receive, even though it's actually not special treatment, is counted against them, and it's attributed to affirmative action rather than to their actual abilities. I think that is a cost of affirmative action. Second, and something I'm actually much more worried about, is I think affirmative action is largely window dressing. It's something that makes white liberals feel better about what's going on without actually accomplishing very much, and perhaps retarding things that might otherwise be done if white liberals didn't feel better about the world. The fact is, the most serious racial problems in our country, not the only racial problems, but the most serious ones, are not about middle-class African Americans who are mostly the beneficiaries of affirmative action. The real problem is with the isolated poor and near poor, and they get very little benefit from affirmative action programs. Third, I do worry that affirmative action feeds white prejudice and white rage. We are in a country, it's not going to be for that much longer, but right now it is still majority white. And I worry that some of the ventilation about affirmative action in the long run obstructs the kind of black-white coalitions that are really the only hope for racial progress. So what's to be done? On balance, I think probably the advantages of a well-designed affirmative action program outweigh the disadvantages, but that's not to say that any of us should be happy where we are. In particular, I think we might think much harder about affirmative action programs that focus on wealth and other forms of disadvantage and not just race. There might be some room for some common ground there. I think we need to do a better job of helping students who are admitted through affirmative action to succeed in the institutions where they are. But more fundamentally, I think both proponents of affirmative action and opponents need to realize that affirmative action is not going to solve our race problem. That problem is much more pervasive, much more deeply rooted, and actually much more serious than anything that affirmative action addresses. I myself think that there is a special burden on people who oppose affirmative action to say, well, if you're not going to do that, what else are we going to do? Because the status quo is simply unacceptable. But that's true of people who favor it also. We all need to give much more careful attention and a much greater sense of urgency about the terrible and continuing racial injustices that mar the United States.
Well, thank you, Michael, for those always interesting comments. Mike and I have debated each other many times over many years, and in all that time, neither of us has changed his views a bit. In any event, we're now going to have a little bit of exchange among the panelists, and then we're going to open it up to the floor. While they're talking to each other. If you want to line up at the 2 microphones there, feel free to do so. Stuart, do you have a
Yeah,
response to?
I'd like to respond. Is this working?
Yes.
Briefly to Mike. His remarks were very eloquent, and I agree with a lot of them, as he agreed with a little bit of mine. In particular, I do think the conservative justices on the Supreme Court have not bitten the bullet and said how they reconcile their philosophy with their position on this. I think that's a good critique. 2, I agree that discussing these issues in terms of the moral desert of the students, when we also have legacy preferences and athletic preferences and all kinds of other things, is not the most productive way to discuss this. I think there's something to it. Where I disagree, or a minor point, Mike said there's no one talking about mismatch theory with the legacy or athletic preferences. Actually, we do have some stuff in our book about it. It's not a lot, but the gist is the athletic preferences. Remember, I said that the problem with mismatch is not the fact of preferences, but the size of preferences. The preferences for legacies, on average, are really quite tiny compared to the racial preferences, the numbers I gave you. And that's mostly true of athletic preferences, except, say, maybe football stars and basketball stars. But I'm against legacy preferences, in part for the reasons Mike gave, and also pretty cool on athletic preferences. But I do think they're distinguishable. I think racial preferences raise bigger mismatch problems and bigger other problems. 2, in terms of implicit bias being an offset, and why we shouldn't call racial preferences, because there are all these built-in preferences and headwinds for blacks. I think that was a much stronger argument in, say, 1968 than it is now. In spite of various surveys where people say various things, it seems to me when you look at 2 applicants who are otherwise identically situated, except one of them has an SAT score and grades that are a standard deviation above the other. He's a poor white taxi cab driver's son. And the other one with the lower grades, et cetera, is a rich black lawyer's son. And you say, we'll take the rich black lawyer's son because he's black. I think it's fair to call that a racial preference, especially in the college context. And I'm just not persuaded, and I think a lot of people more expert than I in this field, including my old friend Bill Coleman, former NAACP Legal Defense Fund chairman, think that white prejudice as a source of the problems of unfairness that blacks encounter in this society is a lot smaller factor than the human capital problems that the black community has, admittedly, as a result of our long and lamentable history of slavery and discrimination. Thanks.
Hans?
Oh, I just wanted to address a point about hypocrisy. In lawsuits, critics of racial preferences also oppose non-racial preferences at the expense of merit. For example, the challengers to the University of Michigan's affirmative action policy in the Gratz and Grutter case argued in their briefs that legacy preferences should be abolished as a race-neutral means of promoting diversity before colleges could resort to using race, because one of the usual requirements in strict scrutiny is that the government entity that wants to use race first has to explore non-racial means of increasing the minority percentage, remove barriers to minorities, rather than giving them an affirmative preference. So the hypocrisy that's discussed is not, it was not present, at least in that case. At that very time, people also discussed this issue. For example, my twin brother published a letter in the Post, the Washington Post, making this very point, which was the University of Michigan, before being allowed to use race, should have to consider non-racial means of advancing diversity, like getting rid of legacy preferences before it's allowed to use race. And the Justice O'Connor's opinion upholding University of Michigan Law School's racial preferences in Grutter utterly fails to address that or many arguments that were made against the use of racial preferences, presumably because there was really no answer to them, because these arguments were ones that should have been winners under the Supreme Court's Bakke decision and its other past decisions dealing with the use of race.
Okay, so
Mike?
First of all, I do think, although there are lots of differences of opinion here, there actually are some agreement. So I don't know what Roger's view is, but I think that the three of us agree we ought to get rid of legacy preferences. That would be a really good thing to do. On Stuart's comments, so I take your point about mismatch theory. The only thing I would say, Stuart, is as somebody who has actually looked at the admissions process at least one institution, I do think people are under a misimpression if they think that this is a process that is scientific, that is carefully tested with lots of regression analyses, and where the discretion is sort of out of it. It's just a mishmash. It is not scientific. It's not careful. There's disagreement not only about who we should admit, but about what we're trying to accomplish. It's just sort of a mess. And I think when people talk about some people getting in on merit and some people not, they ought to realize that this is not something where things are measured precisely and accurately. On the implicit bias point, there I just think we really do disagree. So the point about implicit bias is not, or not just that admissions officers have implicit bias. The implicit bias is much deeper, and it goes on all around us. So way before somebody gets to apply to a college or a university, and indeed way before the person is born, the kind of place the person is born into is affected by what is, I think social science is pretty unanimous about this, just very, very widespread, deep-seated, difficult to root out, not consciously based discrimination against African Americans, prejudice against African Americans. And by the way, one thing that I do think is really important to understand about racism, it's not just people acting from bad motives. The problem with racism is that it is a system that replicates itself by creating the very facts that make it seem sensible to be a racist. So it's not just the imaginings of white racists that black men, young black men, commit more than their share of violent crime. That's a fact. And given that fact, in some ways it's not surprising that these implicit bias tests come out the way they do. But then we have to ask, well, why is that a fact? And I'll just take one more second, Roger. I know I'm going on for too long, but here's a useful sort of parable. So on day one, there's a black waiter and a white customer. And for whatever reason, let's just assume the black waiter has a bad day and he provides lousy service. And so the white customer doesn't leave a tip. On day two, the black waiter says, well, these white customers, they're not leaving tips, so I'm not going to give them good service. So the black waiter gives good service, bad service. On day three, the white customer says, well, these black waiters never give me good service, so I'm not going to give a tip. And once you're off on that equilibrium, it's very hard to break out of it. It becomes a system. And that's the system that's functioning in the United States. Like it or not, we have to do something to break out of it.
You began your remarks just now, Mike, by saying you didn't know what I thought about legacy preferences. Since you've invited me, I'll tell you what I think about them. Namely, I think that they should be allowed in private institutions. And I noticed nobody on the panel picked up on the distinction in my opening remarks between private and public institutions, because of course the law does not permit that distinction in a serious way today. That is to say, if you really want to have affirmative action or discrimination, which is what affirmative action amounts to, then you, as a private institution, ought to be able to do it as much as you want to, because it is, quote, your institution. On the contrary, if it's a public institution that belongs to all of us, you can discriminate only on grounds that are narrowly tailored to serve that institution. That's what equal protection under the law is. And it seems to me that distinction between private and public has been utterly lost today, and with it, freedom of association in the private sphere.
Could I address that?
Yes.
One of the ironies is that the Supreme Court's academic freedom rationale for allowing race to be used in universities seems to apply logically much more to private colleges than public. Because you don't usually think of the First Amendment protecting the government from us, but us from the government. But yet, without really much discussion, it's been applied to both. And now we have not only the Constitution limiting the use of race in admissions, but more importantly, you have Title VI and 42 U.S.C. Section 1981 doing that. Remember, in the Bakke case, the conservative justices did not declare it unconstitutional. They declared it the racial preference program violated Title VI. So even if you get rid of, the constitutional limits on affirmative action, in the higher education setting, you still have this rather clear textual impediment to using race in admissions, because Title VI says explicitly you can't use race or color in federally funded educational programs. And 42 U.S.C. 1981 bans racial discrimination in contracts. So even if we got rid of the Constitution as a restriction on the use of race in college admissions, you would still have thorny litigation over the extent to which such racial preferences violate civil rights statutes like Title VI and Section 1981.
All right, let's now turn to the audience, and we've got time for lots of questions.
One question?
Lots of questions.
Oh, good. James Lowen, sociologist. I want to say something about, coming off of your remarks, about the SAT. The SAT has racial bias built into it. It happens statistically. I'm not going to go any further than that because I just wanted to say, so if we think about no affirmative action, let's admit by SAT, it's not a level playing field. My question, though, is this. The most highly distributed catalog in America is the Sky Mall, which is in front of you every time you fly an airplane. Now that Sears is gone, this is by far more distributed than any other catalog. It's a catalog of catalogs. It has 100 to 300 photographs every issue of people using its products. It has a doorbell that rings all over your house. It has trampolines. It has all kinds of things, but it doesn't have black people. And it pretty much doesn't have Asian people or even Hispanic or Latino people either. I know because I've counted them over the last 15 years in all these catalogs that there's no change, there's no trend going on. The average number of black folks out of 100 to 300 photos, the average number of photos that has one or more black persons is 1 or 1.6, and that's a very light-skinned person. Now, there's no direct racism behind this. Nobody, I don't think, nobody says, how can we screw black America today? Well, I know, let's keep them out of the catalog. Don't think so. But if you are a black model, you have almost no chance of appearing in the most widely circulated catalog in America because of your race.
Could I address
I'm
your
just wondering what you all think, may I finish? I'm just wondering what you all think would be a reasonable answer for this problem.
I want to address your SAT point because the expert testimony of Dr. Stephen P. Klein in the Smith versus University of Washington case establishes not only does the SAT not discriminate against black people in terms of predicting their performance in college, it actually slightly over-predicts. So it does not operate as a mechanism of screening out equally qualified black people.
I want to submit to you my catalog.
Every study that's ever been done in recent history of the SAT shows that blacks do worse in college on average than their SAT scores predict, which I think all by itself completely blows away your first point, I say respectfully.
Well, actually it doesn't. May I reply to that?
Very briefly.
Okay. Yes. There are intrinsic to the formulation of the SAT is a statistical test which makes it impossible to include in the final draft of the SAT any item on which African American students do as well as or better than white students. That test is called the item to scale correlation coefficient, or the point by serial correlation coefficient, depending on your discipline. And it requires, unfortunately and by accident, the SAT to be biased. Now, your point about outcome is a valid point, but it does not show that the SAT is not biased. What it shows is that that blacks underperform in college. However, that underperformance, as I would think you would actually know, because you actually talk about it in some certain ways, has to do with things going on in college, but not things going on in the opposite direction in the SAT.
You're right in the sense that I think the reason for black underperformance in college compared to their SAT scores is mostly a matter of mismatch, is mostly a matter of racial preferences causing them to underperform. However, it seems to me, if, standing back from the fact you were talking about in the design of the test, which I'm not familiar with, it seems to me that to say the SAT is biased against blacks, if it doesn't mean blacks actually would do better in college than their SAT scores predict, I don't know what it means in any meaningful sense of discrimination.
Okay,
Well-
let's have the next question, please.
Okay. No comment on the catalog?
No, we've got to move on.
Well,
Well,
I
that's-
concede your catalog point. You've clearly made a close study of this.
Sir,
Hi. I just want to address two of the panelists. First, Hans, very quickly. How can we make this discussion, debate more public? I mean, I only see this here at Federal Society. It'd be interesting if the rest of the nation would be more informed about what's going on, except that you mentioned and what you mentioned, Stuart Taylor. I think that would be very helpful for this debate. But let's get the other question in. Professor, you mentioned that one of the silly arguments or the worst arguments about against affirmative action is unconstitutional. You do make a good point in your discussion in that when you read a Supreme Court opinion about these kind of racial issues, they tend to go on and on, like 30 pages, which makes it lends itself to you can pick out little snippets as you've done. From John Roberts.
This wasn't a snippet. This was.
What I'm saying to you, that there are a lot of anecdotes and people will give their personal opinions about. That is to say, they're not saying it's simply unconstitutional, it's also bad policy. And you might disagree about the policy and about the different anecdotes. What I'm saying is that I'm kind of agreeing with you. These opinions should be simply a page long saying that it violates the Equal Protection Clause. So my one question to you is, well, what is your view on the Equal Protection Clause with respect to this? And secondly, you mentioned that that the status quo with race and admissions are sort of unacceptable. What do you say to the point that perhaps we should just, I guess we as blacks should just be left alone to sort ourselves out? I mean, there are over 3,000, colleges and universities, and if you graduate from high school, we're probably qualified to be in any one of those schools. So I think if you just leave us alone, I think we'll do just fine. Diversity is kind of a silly sort of reason to admit people to different schools. We'll graduate at higher rates and everything will be just fine.
okay, let's have short answers because we're starting to get a line for the questions. Hans, the first was to you.
Oh, well, I really can't add much to what Stuart said earlier about transparency and requiring colleges to make their admissions policies more transparent. On a substantive note, I mean, I really think the case for racial preferences in admissions is even weaker than for scholarships, because you can benefit from a scholarship, but because of the mismatch effect, you may end up failing out of school because of an admissions preference. So I think that we should consider amending statutes like Title VI to explicitly ban public universities from using race in admissions, even if we don't necessarily take that step as to the use of race in scholarships.
Mike?
The gentleman asked what my view is of the correct interpretation of the Equal Protection Clause. I've written a book about that, and you wanted a short answer, but with regard to race, I'll try to say it in a sentence. I think the overwhelming desire of the people who wrote the Equal Protection Clause was to end racial subjugation in the United States. And what the Equal Protection Clause therefore means is that activities, at least by the government, are unconstitutional where they further racial subjugation. What does and doesn't further racial subjugation is an argument for appropriate debate. My own view is that it's context dependent, so that things that at one time might have promoted racial subjugation might not now, and vice versa. That's the very short version. On leaving blacks alone, blacks have wanted to be left alone in this country for several hundred years, and I think it would be great if white people left them alone. And in particular, if African Americans want to attend predominantly African American institutions, I don't have any objection to that. What I do have an objection to is those African Americans who want to attend other institutions being prevented from attending those institutions by what amounts to pervasive racial bias.
So your understanding of equal protection is not Lady Justice with a blindfold, but without it. Is that the idea?
I have no idea what you mean by that, Roger.
Oh, I didn't think so.
What I
You
think the
confirmed my
framers...
point.
Roger, could I briefly respond to the gentleman's point about how to have a more public debate? As Hans said, I think, and as I may have implied earlier, I think transparency is the best way to have a more public debate. And the fact is that although the elites, and I don't use that in the sense of the bad guys, you know, the highest people in our society, the most privileged people in our society, tend to be very strongly pro-racial preference, CEOs, professors, etc. And the mass of Americans tend to be very anti-racial preference, as every poll shows. So one reason we don't have a more public debate is that the people at the top don't want it out there being discussed. They just want to do it. And when a politician takes up the cause of saying there's some problems with racial preferences, they get attacked mercilessly in the media and also by Jesse Jackson, Al Sharpton, whatever, which is why I think not one leading politician in the United States since 1996, unless I missed one, has ever made a major issue of critiquing racial preferences, even though I think it's safe to say most of the Republican Party, at least, and a lot of Democrats don't like them. I'd also like to sneak in one quick response on an off point to Mike. The following was written by my friend Bill Coleman, who I mentioned earlier, who sat next to Thurgood Marshall when Brown versus Board of Education was being argued, one of the great civil rights leaders and as well as black lawyers in the United States. Bill wrote in his memoir, "Today, race in and of itself usually is not an impediment to success at the highest levels of our society, or at any level for that matter," end quote. Now, that's not a statistical study, but I put a lot of stock in it.
Sir.
Hi, my name is Joel Mandelman. I'm an attorney. I filed briefs in the Fisher case and in Schuette on behalf of the petitioners. One question for Mr. Taylor and something else I wanted to ask Mr. Seidman in light of what he's been saying. First, about mismatch. If you say the student doesn't quite have the qualifications to make it at MIT, but he'd do better at a less competitive institution. If you want to be an electrical engineer, you got to pass calculus and you got to be able to do integral and differential equations. I don't care where you're going to school. Now, if you don't have the ability to pass the course, you're not going to pass it at MIT and you're not going to pass it at Mississippi State either. So I don't quite understand.
I think you are going to pass it at Mississippi State. I mean, the whole theory of mismatch is professors and teachers tend to teach to the median of the class. If Unit X of calculus is going to take the median student at MIT 2 weeks to learn, or let's say the median student in some high school, and it's going to take the less prepared kid 3 weeks or 4 weeks to learn, then the class proceeding at twice the pace of the less prepared students is going to leave them lost. If it's taught at a pace that they can absorb and they're allowed to gradually bring up their game, that's why HBCUs produce so many scientists, engineers, doctors, and professors. It's not, those are people who, had they gone to, let's say, Yale or Harvard, might well have washed out because the competition at that level was too fast for them. It's got a lot to do with how long it takes to learn things as opposed to whether you can learn them at all.
But then at some point, you're not going to cover the same amount of material in the course.
No, at some point you're not, and it's probably fair to predict that the engineers coming out of MIT are going to have fancier careers than the ones coming out of Howard University. But the ones coming out of Howard University are still going to be good engineers. They're going to have, and they're likely to have perhaps more fulfilling careers than if they'd gone to another college where they couldn't make it as engineers, and they ended up majoring in sociology or something.
What I wanted to ask Professor Seidman, in light of everything that he was saying, the University of Texas, which to me is one of the most passionately racist institutions in America, they've got a quota for everybody who's a minority, nevertheless imposes very rigid, non-quota standards. If you want to get into the engineering school, the business school, the School of Business Administration, the School of Nursing, you must have gotten certain scores on the SAT Advanced Math exam or on the SAT Advanced Placement exam, or you don't get in and you do not get any racial preference. Now, why don't you criticize that as being inconsistent with their alleged need for diversity, or in fact, isn't the University of Texas faculty conceding that grades really do matter and that that educational attainment does matter because they exclude, I'm quite certain, a disproportionate number of blacks and Hispanics from the engineering school and also from majoring in physics, chemistry, and biology because they don't have the science and math scores that non-minority students have. But nobody ever criticizes that.
So I'm at somewhat of a loss for how to answer your question. In the first place, I don't really know very much or anything at all other than what's been in Supreme Court cases about the practice of the University of Texas.
Read the catalog.
I'm sorry?
Read their catalog. It's got the admission requirements.
So I have to confess, I haven't read the catalog the other gentleman mentioned, and I hahaven't read this catalog either.
I think it's in here somewhere. Here, read it right now.
It's online.
Reading catalogs. But look, I don't think, I am with Stuart, at least to this extent. I don't think it helps anybody to set people up for failure. So if somebody really is not going to succeed, then it's not doing them a favor to admit them, and that's a bad thing. I do think that a lot of the problems Stuart mentions could be solved by doing more to help people once they get there. I also think that some of the problem actually just doesn't exist because some of what looks like special preferences is just treating people equally. And I think some of the underperformance by African Americans is caused by a variety of subtle disadvantages, race-based disadvantages they suffer once they get to the institution.
Okay, let's go to the next question, please.
Hi, I'm Janice Walt-Grenadier, and I am an entrepreneur, and I actually have on my desk a contract from Sky Mall. And it's really important that nobody walks out of here thinking Sky Mall picks and chooses who's good. I mean, they do pick and choose, but everyone pays to be in there, and it's an opportunity, an affordable opportunity for small businesses and products that are out there. And so for anyone to walk out of here thinking that they are in any way racist would be wrong. I
In other words,
apologize.
you can buy your ad there?
Excuse me?
You can buy your ad?
Everybody pays to be in there. Nobody is in there for free.
So therefore, the idea is that if it comes out that way, it's just because other people didn't buy their way in.
Correct. And I mean, you have to prove your product. You have to prove that your product is one that's made well and everything like that. Not at one point has anybody seen me from Sky Mall, nor have they known anything more about me than what's in my application to go in there online.
So I don't think, I don't know the first thing about Sky Mall, but in defense of the gentleman who spoke before, I don't think he said that any of this involved conscious racism. The question that you haven't answered is whether he's correct that of these hundreds and hundreds of models who appear in Sky Mall. None of them are African American. Now, I don't know the answer
Okay,
to
but
that.
you know what the bottom line is? In my product, I choose what goes in my ad. I'm paying for that ad. Everybody who has an ad in there has paid for it and
But
decided
what is
it's
the
gonna-
relevance of that? Are the models in your ad African American?
Mine is just my product, which most of them are just your product. But if, say, for instance, somebody owns a product that is a beach product, and they have the product in the pool, they get to choose who's going to be in that ad. And they're not necessarily thinking, oh my God, I need to put an Indian in there, I need to put an African American in
Oh,
there.
just a
I
minute.
need
Can
to-
I just cut this short? Gail
Sure.
just brought me an ad from Sky Mall, and it looks like America.
It looks like what?
America.
Yeah, I mean, it definitely has all
I mean,
different
it's
things.
it's
But
a
the bottom-
diverse group of kids, except they're all girls. You know, there's. All right. Okay. Let's.
But I'm sorry,
all
I
right, all
just
right,
didn't
let's-
want anyone
let's-
to walk out of here
okay.
thinking
All right,
that
thank
that
you.
was on purpose.
That was a very useful point of information, sir.
Hi, Michael Finger. I'd like to raise a question about financial incentives for mismatch. The choice between a wealthy black applicant and a poor white applicant to Harvard is easy enough to make because one of these will apply for financial support, the other one not. The question is when you get to even things, and it relates to a study I read recently about you can obtain a student loan even to go to law school, even though your LSAT score would predict that you have one chance in 1,000 of ever passing the bar exam. The question then is, particularly for Mr. Taylor, to what extent does financial support from outside the university reinforce the idea of the process of mismatch, to the extent that if you have a student body of this, or if you have a black student and a white student, it's easier to find outside money to support the black student than the white student? Or just generally speaking, I'm looking forward to reading your book. What have you looked into the idea of financial incentives reinforcing this business of mismatch?
We didn't get into financial incentives much, and I don't know much, so I'll just make a couple of quick remarks on that front. There certainly are scholarship programs encouraging blacks to come to the college that are not available to whites. And it's usually just a matter of the competition among the colleges to get the most highly qualified blacks they can find. And one of the many ways you do it is discriminating against the whites and Asians, another is scholarships. As to, now there are probably countervailing financial incentives, as you suggest, at some places in favor of people who can pay. And certainly, you know, there, on average, more white people can pay. I think those are offset. And of course, the fanciest colleges purport to be need blind or almost need blind in their admissions.
The pay-as-you-earn program is putting taxpayers on the hook to a huge extent for this. The Obama administration has expanded pay-as-you-earn, and basically, no matter how ridiculously much you borrow for law school, even if you have a very low score and you're not going to get a decent law job, they will write off your loans at the end of 20 years, even if you hadn't paid them back based on the small percentage of income you have to pay, or at the end of 10 years if you manage to find a government agency or nonprofit to employ you. So taxpayers are very heavily on the hook for this now, for these loans, because theoretically you're supposed to pay them back. But since you only have to pay a certain percentage of your net income, and many of these people with very poor scores are going to have low annual incomes, they're never going to pay it all back. And you, the taxpayer, will pay for it, thanks to the administration's expansion of that program.
I'm shocked. If we can cut off the questions right with these two, okay? Yes, ma'am.
My name is Louise Epstein. I'm a recovering lawyer. I graduated from Harvard Law School, just like you guys.
Another one.
And I also, in sort of my post-law career, I became the president of the PTA at Thomas Jefferson High School for Science and Technology. So my question is about the overlap between Title VI, STEM, the mismatch theory, and transparency in particular.
You want
so-
that in less,
Yeah, and I'll
than,
try to do
less
it
than
really
a
quickly.
semester?
Yes, that's right. So back in 2012, in the summer, there was a complaint filed with the EEOC against Fairfax County Public Schools regarding the admissions policies of Thomas Jefferson.
Was it OCR or EEOC?
It was I'm sorry, it was OCR, sorry. It was the Office of Civil Rights at the Department of Education. That complaint was factually inaccurate, and I know that from personal knowledge. Meanwhile, the faculty at the institution have pointed out that efforts since 2005 to modify the racial composition of the student population have neither succeeded in that way, but what they have done is created massive academic diversity that led to the need for remediation of about 1/3 of the student population. At the same time, the complaint has led the administration to basically be paralyzed because they are fearful of disclosing any information because it's all privileged now, because it's subject to sort of the veil of secrecy that permeates these kinds of complaints. So going towards the transparency question, what I'm going to ask is, what purpose is there any limit on what cannot be disclosed and what cannot be done while one of these complaints is pending? And also, is there any limit on how long a complaint can be left out there to languish and just paralyze an institution?
Just a quick answer, please.
I mean, the real problem is substantive, which is that you have disparate impact guidelines being imposed based on a dubious statutory basis by the federal OCR. OCR argues that they can invalidate a standardized test or some other selection criterion not based on intentional discrimination, which is what the Supreme Court has said is needed to bring a private lawsuit under Sandoval, but for disparate impact. And in footnote 6 of its Sandoval opinion, the Supreme Court said that unlike the workplace, in the educational setting, it's very strange to even suggest that disparate impact would apply. Unfortunately, it did not definitively rule out that theory as an administrative investigation standard. And so the administration has not only continued pushing its disparate impact rules, which are of dubious validity, but it has expanded what it defines as disparate impact beyond its parallels in the workplace in certain respects. So in a sense, I don't know what to expect from this investigation because they've been pushing the envelope a lot. Like in the area of school discipline, they have been essentially arguing that a crude bottom line greater number of disciplined black students than white students shows disparate impact, even though in the workplace setting, a mere crude bottom line disparity doesn't constitute disparate impact unless you trace it to a particular policy. So they're demanding what is essentially racial quotas in student discipline, arguing that you should discipline no higher percentage of blacks than whites, even though the adolescent murder rate is 10 times as high among blacks as whites, and the murder rate among adults is 6 times as higher among blacks than whites. So they're still demanding what's effectively a racial quota in discipline, even though the Seventh Circuit in the People Who Care case said that was unconstitutional back in the 1990s. So given their manifest willingness to disregard settled, basic statutory limits on their jurisdiction, I don't think anybody can predict what they're going to do. And I can see why you're concerned about, confidentiality, because the more information they have, maybe the more mischief they can do.
Okay, one last question, please.
For Professor Seidman, my name is Bob Popper. I'm from Judicial Watch. I just wanted to make explicit something that I think I've been hearing from you. Do you believe that the protections of the Equal Protection Clause do not apply equally to white and to black citizens?
The protections apply equally to everybody, but what's protected against is racial subjugation. That was what the framers had in mind. That's the chief concern they had.
All right, I'm told that lunch is in the Chinese room. Stuart Taylor will autograph the book that you've picked up right outside. And please join me in thanking our panel here.